Step out here right now, sir. I'm fine where I am. You still haven't told me why you're here. I said step outside. Don't make this harder than it needs to be. Without a warrant, you don't come into my house. Fourth Amendment. I'm not stepping out. Yes!
The taser fired. Marcus Ellington, 24 years as a federal prosecutor, won 200 cases, a conviction rate that made defense attorneys lose sleep, collapsed onto the hardwood floor of his own home. He hadn't thrown a punch, hadn't raised his voice, hadn't moved an inch toward the officer. He had quoted the Constitution. 9 months later, a federal judge signed a $7.4 million judgment against Officer Craig Dunlap. Then came the criminal charges. Then came the end of everything Dunlap had built. 4 security cameras recorded every second. So did a 16-year-old girl from a second-floor window. Neither of them blinked. Before this goes any further, what state are you watching from? Drop it in the comments. If you believe no badge puts anyone above the law, subscribe. These stories don't tell themselves. Someone has to keep the record. Marcus Ellington had earned this Sunday the hard way. 24 years as a federal prosecutor, 1,200 cases. A conviction rate that made defense attorneys check his name twice before walking into court. He had retired 2 years earlier, clean record, full pension, no regrets. One goal: left a house with a yard big enough to work with his hands. This was that house. He and his wife Patricia had closed on the property 8 weeks earlier. Quiet street, established neighborhood. Exactly what 2 decades of early mornings and late courtroom nights had been building toward. That Sunday, Marcus was replacing a section of front fence that had started leaning after a storm. Old jeans, work gloves, a post digger borrowed from a neighbor the week before. He was not in a hurry. He had nowhere to be. Officer Craig Dunlap drove past the property on Crestview Lane sometime around 3 in the afternoon. He saw a black man doing heavy labor outside a large home in a neighborhood Dunlap considered his territory. He slowed down. Something he would later tell Internal Affairs didn't fit. He did not call dispatch. He did not run the address. He did not check for any complaint, any call for service, anything. He circled the block, came back alone. 9 years on the force, 11 civilian complaints filed against him. Not one had resulted in formal discipline. He had learned correctly that there were no consequences for men like him. He was about to learn how wrong that was. Dunlap parked at the curb and walked up the driveway with the easy confidence of someone who had never been told no and expected today to be the same. Marcus heard the footsteps and straightened up. He set down his tools, pulled off one work glove, and waited. His body language was open, hands visible. Nothing threatening about any of it. "Can I help you, officer?" Dunlap stopped a few feet away, one hand resting near his belt. His eyes moved across Marcus slowly, the work clothes, the tools, the house behind him, and something in his expression made clear he had already decided what he was looking at. "I need you to verify you live at this residence." Marcus blinked. Not out of confusion, out of recognition. He had seen this before, not from this side of it, but from the other. He knew exactly what was happening and exactly what it meant. "This is my home," Marcus said. "My name is on the deed. My name is on the mortgage. I've lived here for 8 weeks. I'm going to need you to prove that. I'm happy to show you documentation. My driver's license shows this address. I have mortgage papers inside, deed of title, utility bills. Everything you need." Marcus kept his voice level the way he had kept his voice level in front of federal judges for 2.5 decades. "I can bring all of it to the door." "Step outside first." Marcus looked at him steadily. "Officer, I don't have to step outside. You have no call for service. No complaint has been filed. You have no reasonable suspicion of any criminal activity. Under the Fourth Amendment, I have the right to remain inside my home unless you have a warrant or probable cause. I'm offering to show you proof of residence voluntarily. That's more than the law requires me to do." Dunlap's jaw tightened. Most people didn't talk like this. Most people didn't know what reasonable suspicion meant, let alone cite it back at him in a complete sentence. The calm was worse than anger would have been. Anger he knew how to handle. "Step outside so we can sort this out. We can sort it out right here." Upstairs, a curtain moved. 16-year-old Danielle Ellington had been in her room when she heard the voice at the front of the house, the flat, hard tone that didn't sound like a neighbor stopping by. She moved to the window that faced the driveway, looked down, and saw a police officer standing over her father with one hand near his weapon. She picked up her phone and pressed record. She didn't say anything, didn't call out. She understood without anyone telling her that the most useful thing she could do right now was stay quiet and keep the camera steady. Across the street and 2 houses down, Dr. Raymond Okafor stepped onto his front porch. Retired professor of constitutional law, 31 years at the State University, still sharp enough to publish. He had been reading when he noticed the patrol car at the curb. He put down his book, walked outside, and stood at the edge of his property where he could see and hear clearly. He did not intervene. He watched. Around the side of the house, the first of 4 security cameras continued recording in high definition. Marcus had installed the system 10 months earlier before the move, after a string of break-ins in his previous neighborhood. 4 cameras, wide angle, motion activated, continuous loop with cloud backup. Every camera was running. Dunlap knew none of this. He was focused on the man in front of him, calm, unmoving, annoyingly well-spoken, and the growing feeling that this stop was not going the way his stops went. He had walked up the driveway believing he held all the power in this situation. He was standing in the center of a courtroom that had been recording for the past 4 minutes, and he hadn't noticed a single camera. Dunlap had been standing on that driveway for 6 minutes, and he was done being patient. "Sir, you are obstructing a lawful investigation. Step aside or I'm coming in." Marcus didn't move. His voice stayed exactly where it had been from the beginning, measured clear, the voice of a man who had spent 24 years making sure juries heard every word. "There is no lawful investigation. You have no warrant. You have no probable cause. You have no call for service on record." He paused one beat. "I know because I spent 2 decades prosecuting cases that started exactly like this one." Dunlap stepped forward anyway. "You are entering my home without a warrant," Marcus said loudly and precisely. "I do not consent to this entry. I do not consent to any search of this property." He wasn't saying it for Dunlap. Dunlap had already made his decision. Marcus was saying it for the record, whatever record existed wherever it was being kept. 24 years in federal prosecution had taught him one absolute rule: say the words out loud, say them clearly, and say them where something is recording. He didn't know yet about the 4 cameras. He said it anyway. Dunlap pushed past the threshold into the front entryway. Upstairs, Danielle pressed herself closer to the window. Her hands were steady. The phone didn't waver. What she filmed in the next 90 seconds would be played in a federal courtroom 9 months later. Patricia Ellington came out of the kitchen when she heard her husband's voice shift. Not in tone. Marcus never lost his tone, but in volume. She had been married to this man for 22 years. She knew the difference between him speaking to someone and him speaking for the record. She came around the corner into the entryway and stopped. A uniformed officer was inside her house. Her husband was backed against the wall, hands visible, jaw set. The officer's hand was moving toward his equipment. "What is happening?" Her voice came out quieter than she intended. "Ma'am, stay back," Dunlap said. "This is my home. Stay back." Marcus looked at his wife for 1 second. Just one. Long enough to tell her, "I know what I'm doing. Don't make it worse." She read it the way she had read him across 2 decades of hard situations, and stepped back 1 pace, her hand finding the wall. Dunlap grabbed Marcus by the arm and turned him toward the wall. "You are under arrest for obstruction of a police investigation." "I did not obstruct anything," Marcus set his cheek now against the wall of his own home. "I asserted my constitutional rights on my own property. You have no legal basis for this arrest, and you know it." The handcuffs clicked into place. Upstairs, Danielle made a sound, small, involuntary, quickly swallowed. She kept filming. Patricia's hand was already on her phone. She dialed 911, walked to the far end of the hallway, and spoke in a low, controlled voice. "I need to report an unlawful entry. An officer has entered our home without a warrant and has arrested my husband without cause. We need a supervisor at this address immediately." She gave the address. She gave Dunlap's badge number, which Marcus had read aloud twice during the confrontation, and which she had memorized without meaning to. She hung up and walked back to the entryway where her husband was standing, handcuffed in the home they had bought 8 weeks ago, and she looked at the officer who had put him there, and she said nothing. There was nothing to say. The cameras were saying it for her. Dunlap keyed his radio with the practiced calm of someone who had written his way out of bad situations before. "Dispatch, this is Unit 22. I have 1 subject in custody at 4 Crestview Lane. Subject resisted contact and obstructed investigation. Requesting backup." He believed what he was building. He had built reports before, shaped them, framed them, used language that made his decisions sound like procedure. It had worked 11 times. There was no reason it wouldn't work now. He did not know that camera 1 mounted above the garage had captured his approach from the curb. He did not know that camera 2 at the side gate had recorded the full 6-minute conversation in the driveway. He did not know that camera 3 facing the front door had recorded the moment he crossed the threshold. He did not know about camera 4 at all. He did not know about Dr. Raymond Okafor, who was still standing on his porch across the street, who had a near photographic memory for procedural detail, and who had already decided he would be making a formal statement before the day was over. He did not know about the 16-year-old girl on the second floor, whose phone had been running for 8 uninterrupted minutes. Dunlap stood in the entryway of Marcus Ellington's home, confident the report would hold. Every camera on the property disagreed. Sergeant Diana Holloway arrived at 4 Crestview Lane 11 minutes after Patricia's 911 call, 28 years on the force. She had seen bad stops before. She walked through the front door, took one look at the scene, and went very still. A black man in his 50s, handcuffed, sitting upright on his own couch. A woman standing beside him, arms crossed, eyes dry and hard. A 16-year-old girl on the stairs, phone still in her hand. And Dunlap standing near the entryway, report already half constructed in his head. Holloway looked at the family photos on the wall, the framed university degree above the fireplace, the mail stacked neatly on the side table, all of it addressed to this house. She pulled out her phone and typed the name from the nearest piece of mail. Marcus Ellington, Northern District, Federal Prosecutor, 24 years. She read the result twice. Then she looked at Dunlap. His face told her he already knew. The confidence he had carried through the door was gone, not all at once, but the way a structure goes when the foundation cracks. Still standing. Not for long. "Uncuff him," Holloway said. "Sergeant, the subject resisted. Uncuff him now." The handcuffs came off. Marcus rolled his wrists once, stood up straight, and looked at Holloway with the measured patience of a man who had been waiting for someone competent to arrive. "Sergeant," he said, "I want to walk you through what happened here, because I want it on record before anything else is said or written." Holloway nodded. She had her notepad out. Officer Dunlap approached this property with no call for service, no complaint, and no reasonable suspicion of any criminal activity. He demanded I exit my home without legal justification. When I declined and cited my Fourth Amendment rights, he crossed the threshold of this residence without a warrant and without my consent, which constitutes illegal entry under Title 18, Section 1038, and it violates the Fourth Amendment protections affirmed in Payton versus New York. Marcus paused. He then placed me under arrest for obstruction, which requires an underlying lawful order to exist. There was no lawful order, which means there was no obstruction, which means the arrest itself was unlawful and constitutes battery under state statute and excessive force under 42 U.S.C. Section 1983. The room was completely quiet. Holloway had stopped writing. Not because she wasn't listening, because she was listening too carefully to write. Dunlap said nothing. There was nothing to say. Every citation Marcus had given was accurate. He knew it. She knew it. Marcus had known it from the moment Dunlap stepped onto the driveway. "I also want you to know," Marcus continued, "that this entire incident was recorded from 4 separate angles." Danielle came down the stairs and handed her phone to Holloway without being asked. 8 minutes and 40 seconds of footage, continuous, clear audio. The driveway conversation, the threshold crossing the arrest, all of it captured from an angle that showed everything Dunlap's body camera would have shown if he had remembered to activate it. He had not activated it. Holloway watched 2 minutes of the footage and called her lieutenant. The security system footage took another 20 minutes to pull. 4 cameras, every angle. Camera 2 had captured the full driveway exchange in enough detail to read Dunlap's expression as he approached the slow scan, the assumption already formed before a word had been spoken. Across the street, Dr. Raymond Okafor gave his statement to a responding officer in the precise, structured language of a man who had spent 31 years teaching law students how to construct arguments that held up. He had observed the entire incident from the moment Dunlap parked at the curb. He described what he saw in sequence without interpretation, without embellishment, and what he described matched the footage frame by frame. Dunlap's report said the subject had resisted contact and obstructed investigation. 4 cameras said otherwise. A 16-year-old's phone said otherwise. A retired constitutional law professor said otherwise. The report didn't survive the afternoon. Dunlap handcuffed a man who spent 24 years upholding the law inside that man's own home. A federal judge later put the cost of those 9 minutes at $7.4 million. Was that enough? Drop your answer in the comments. I want to know what you think. The Internal Affairs investigation opened the following Monday and took 4 weeks to complete. What they found had been sitting in the files for 9 years. 11 complaints against Officer Craig Dunlap. 9 of the 11 involved Black or Hispanic civilians. 8 included allegations of unlawful detention or illegal entry. 3 included accusations of physical force without justification. Every single complaint had been reviewed. Every single one had been closed without formal discipline. The investigating officer noted in his report that several complaints had been flagged by junior officers for escalation and had been redirected by Dunlap's direct supervisor, a lieutenant who had worked with Dunlap for 7 years and who described him in annual reviews as instinct-driven and assertive in the field. Instinct-driven. That phrase appeared in 3 separate performance reviews. The same instinct that had told Dunlap something didn't fit when he saw a Black man doing yard work outside a large house in a quiet neighborhood. The same instinct that 11 complainants had tried to put on record and had been ignored 11 times. It was not instinct. It had never been instinct, and the files, once someone finally looked at all of them together, made that undeniable. The lieutenant was placed on administrative leave pending a separate investigation. The pattern that 9 years of paperwork had buried took Internal Affairs 4 weeks to uncover and 48 hours to make public. The federal lawsuit was filed on a Tuesday morning, 14 days after the arrest. Marcus's attorney laid out the charges with the same precision Marcus had used in federal court for 24 years. Illegal entry, unlawful arrest, battery, civil rights violation under color of law, intentional infliction of emotional distress. 2 defendants named Officer Craig Dunlap personally, and the department that had ignored 11 complaints and let him operate without consequence for 9 years. The department settled their portion within 7 months. Their attorneys looked at 4 camera angles, an 8-minute phone video, and a statement from a retired constitutional law professor, and they settled. Dunlap fought it. He lost. The federal judge signed a $7.4 million judgment. Because Dunlap had been named as an individual defendant, because the court found his actions fell outside the scope of qualified immunity, his personal assets were fully exposed. He owned a house with $180,000 in equity. It was sold. He had $74,000 in a retirement account. It was emptied. His wages were garnished at the maximum allowable rate. They would remain garnished for the foreseeable future. His attorneys told him privately that at current earnings, the remaining judgment would outlast his working life. The criminal charges came separately. The district attorney filed on illegal entry and battery. The trial lasted 3 days. Danielle's footage played twice for the jury, once in full, once in slow motion at the threshold crossing. Dunlap was convicted on both counts. He was sentenced to 14 months in county jail, 3 years probation, and permanent revocation of his law enforcement certification. He would never carry a badge again. He served 11 months. He was released at 40 years old with a felony record, a garnished paycheck, and a name that appeared in the first result of any search engine query about civil rights violations in the district. The lieutenant who had buried 9 years of complaints did not survive the separate investigation. He resigned before their findings were published. The report came out anyway. It documented a pattern of complaint suppression spanning nearly a decade. Not one officer, not one incident, but a deliberate administrative practice of redirecting escalated complaints away from formal review. The department was placed under a federal consent decree. New protocols required independent verification of any resident's status before an officer could initiate contact at a private residence. Body cameras became mandatory with automatic activation. Complaint reviews were transferred to an outside oversight board with no departmental ties. None of it brought back the afternoon Marcus had planned to spend fixing his fence. All of it came directly from what happened on that driveway. Marcus Ellington still teaches. 2 mornings a week, he stands in front of a classroom at the State University and teaches Fourth Amendment law to students who will become attorneys, judges, public defenders, prosecutors. The case that sits in the middle of his Fourth Amendment unit is United States versus Dunlap. He doesn't present it as his own story until the end of the session. He lets students analyze the footage, examine the complaint history, walk through the legal violations step by step. Then he tells them the man in the video is him. Every semester, the room goes quiet in the same way. Danielle's footage has been incorporated into training curricula at police academies in 7 states. A 16-year-old with a phone and a steady hand produced 8 minutes and 40 seconds of material that is now shown to officers in their first year of service as an example of what bias looks like from the outside, what it costs, and why cameras always win. Danielle is 18 now. She has applied to law school. When reporters ask Marcus if he feels like justice was served, he gives the same answer he has given every time. Justice isn't a feeling, it's a record. The record exists. That's what matters. That footage recorded by a teenager from a second-floor window changed how a department trains its officers and how a federal court defines accountability in this district. If you believe transparency is worth fighting for, share this video with someone who needs to see it. Subscribe because the next story in this series involves a pattern even larger than this one, and the evidence is just as undeniable. And if this case made you think, drop your reaction in the comments. This conversation is worth having out loud.